Tip FM's Tip Today.
With Slattery's Garage, Puck On. Over half a century driving the people of Tipperary and surrounding areas with quality, reliable and economical vehicles, new and used. Call the sales team today to discuss your next car or van on 067 24111.
Thanks, Pat, and welcome back to the final hour of Tip Today, 1800 938 007. Some disputes emerging about the numbers deported by Obama as opposed to Trump. There's some new figures now, and the argument there is that Obama deported 4.2 million and Trump 2 million, with Biden as 1.49 million. So make what you will of that. Delighted to be joined as usual now on a Tuesday even by John Lynch of Lynch Solicitors. Good morning to you, John.
Good morning.
Good to see you today. Rows about numbers deported and stuff, yeah.
You'd imagine you shouldn't be rowing about numbers. Surely that's a matter of fact of all things, no?
Well, I'm not sure about that, you see, because Obama, what he signed off on as opposed to who were deported at the time, all sorts of that sort of
funny. Somebody said
stuff.
this to me over the weekend. They were talking about the whole ICE thing and the controversy, which, of course, now is subject to so much media coverage, as in whatever, and I wasn't really watching it a huge amount, but one of the things that somebody was talking about was exactly that, i.e. that Trump isn't the worst, that Obama was worse, etc., etc. And it's interesting to try and drill down the figures.
It's very, but you see, to get to the truth of it all,
correct,
is what the problem is. You're going to talk to us once again about resolutions, the legal resolution. Well, I'm delighted because normally it goes into March.
Yeah. I've decided I'm going to do a whistle-stop tour of it. I mean, we covered Will's enduring powers of attorney, I think, the last time.
Yes, we did.
And I mean, the other area, the starting area, and it has the same resolutions funneling every year, is the whole area of family law. Yeah. Because, funny, the trend is often very much the case that in January we get a lot of inquiries. And I think they've, I was going to say they have done kind of the stats on it, and the problem is that different times of the year can be quite stressful for families, and one of those times is around Christmas.
That families might break up or divorce
or lead to a point where they need to.
Would that be because they say, okay, we'll get through Christmas, we'll get ourselves into the new year, and then we'll look at that? Is it as pragmatic as that?
Well, I think it's more to do with the fact that Christmas is a time when families get together, and unfortunately, when families get together, it can sometimes show the differences that will emerge, and then come January, then it's kind of, look, need to do something about this. We can't have another Christmas like this, is kind of the general experience that I've had when I'm talking to people in January. Or alternatively, the other one is that people, as you say, leave it off until the new year, and they don't want to spoil Christmas, which is fair enough, and it's a very laudatory way of dealing with it. And the other thing, of course, is that people resolve things in the new year. So they say, well, I'm not going to have another year of this. So I presume there's a lot of, there'd be a lot of reasons, but those are the ones that I'd often come across.
But that thinking would reflect itself in the numbers that you would see in January and February.
It shows itself in the numbers. Same time as post-summer holidays. Same time, people are together for a prolonged period of time, and it shows, the fractures that are there, and then people decide, look, can't have another one of these, and so you do see kind of spikes. And
so if people are looking to separation,
well, I mean, the very first thing that and we've said it many a time, you and I have been talking about it, the very first thing is to try and do it, if you can at all, by agreement. I mean, there are going to be cases where it's going to be impossible, but the default position should be to try and reach some sort of agreement. And the primary reason in most cases why that's the paramount consideration is because at the end of the day, you separate over a period which is a very short period in your life, but the impact of that separation can follow on for years afterwards. So if people were able to stand back and look at it and say, okay, yes, it's traumatic, yes, it's difficult, but the repercussions of doing it the wrong way could be huge in terms of your relationship with your children and or your relationship with the separating the other party. And interestingly enough, an observation that was made to me by a German national who was at an event, and the event was what I would call a blended family event, i.e. that parties were separated, whatever. And he said to me, I'm surprised there's none of the former spouses here. And I said, why would you expect the former? He said, well, in Germany, if there's a family event like this, no matter what it is, you'll have former partners there. And I thought that was really interesting. And a really interesting observation, because to a certain extent, I can see the logic of it, that after however many years, it should be possible to re-establish some sort of relationship with your ex, unless, as I say, you're in one of those scenarios where it's so acrimonious and so damaged that it isn't possible to do it. But as a default, so part and parcel of that, then I would say, is you may not be able to sit down and at the point of the separation to try and agree terms, if you like. That might be just a little bit too far to go. But certainly when somebody comes into me, I will always say, well, let's have a look at the situation here. Let's see what exactly are we dealing with. And I can give you some sort of a steer as to how I think a court will look at this, or how I think is in the best interests of all the parties, which is what the criteria the court uses. So the court's dictate is look to the interests of all of the parties within the scenario and see if you can do the best you can in the given circumstances. Gather the information, and on the basis of the information that you have, come up with a solution, devoid of any partisan view one way or the other, if you know what I mean. That's the mandate that the courts has.
Right. And so would you look to mediation first then?
You would.
Yeah. Okay.
Well, I'd even look to trying to get the client into the position, into the mindset of looking for agreement rather than confrontation. So in other words, can you get, is there scope here to work something out? And if there is, and you mightn't even, in certain instances, you mightn't even have to go to mediation. I mean, mediation is a very broad term.
Yes.
I mean, a lot of solicitors mediate anyway, in the sense that you have a colleague that you deal with quite frequently. You're on the phone, you say, well, here's the scenario. Here's what we think will work. Okay, what do you think will work? Okay, what's your client saying to you? What's my client saying to you? Okay, is your client listening to you? Can they hear what you're saying? And are we in a position to reach an agreement, which ultimately would more than likely be reached anyway in a court scenario?
But John, you'd always end up with two solicitors, surely.
But it's right that one should, because you need independent, separate advice.
Yeah.
But that doesn't mean you have to have opposing. Now, this is one of my hobby horses, I suppose. Just because I'm acting for one side, as in one party, doesn't mean it's one side.
Yes, or that you're trying to screw the other side.
Exactly, or that you're trying to do a deal that's going to be totally detrimental to the other side. What you're trying to do is ensure that your client is properly represented, and that whatever the outcome is would be consistent with what a court might determine as the outcome. So that's your that would be my mandate looking at it. So that, to me, then I would say to a client, well, this is what I think will happen if you go to court. This is what you want, but what you want doesn't match what's going to happen. So the common one, for example, somebody will say to you, well, I contributed a huge amount to such and such. I financed this and I did whatever. So my contribution was hugely much more significant than the other party, because they were at home and I was earning all the money. And I would say, well, the court looks at it not in that. First of all, there are certain rules and guidelines the court will use, but by and large, 99 times out of 100, which is probably too high, in most cases, what you have is not enough to go around. In certain instances, you will. Yeah. And if you do, that's a different scenario. But in most cases, people aren't going to be... I mean, it just makes logical sense if you think that if you split two into two separate units, it's going to cost more.
Of course it is.
By definition.
And then you add the children.
Correct. And then you add looking after the children. And then you look to the needs of the children and trying to do what you can. Even in most situations, couples are struggling with that, trying to do the best they can.
Yeah.
So then add in the complication that you're now got two separate households. So the reality of it is, taking into account additional contributions over the year doesn't work because there isn't enough to go around. So from a pure common sense point of view, if you were to do that and apply that logic, you'd have very little left for the other party. So the reality of it is that the court in most situations will do a 50-50 exercise on it. Now that's a very broad statement, but as a rule, as a default, and again, as I say, as a default position, that's your starting point.
And the family home there, John, is that included in the 50-50? So are we?
It can be, and the family home is included. You see, again, one of the criteria that the court applies is accommodation needs. So, and it's one of the, if you were to put a kind of a matrix of priority of rules or applicate a rule set, if you were to make a rules and go, well, what's rule number 1, rule number 2, rule number 3, one of the top rules, one of the ones at the top is accommodation needs. You can't have one out in the street and the other one living in the house. So you have to try and work that. And where the problems will arise then is where you have the family home and you have children, and the default position can often be, well, you don't have a choice but to sell it. And that's often, I've been in court where the judges look down at one of the parties and say, look, I'm sorry here, but we don't have a lot to go with here. If you get the house, she or he is out and it doesn't have an option. So you have to look to those options all the time. You have to look at accommodation. That doesn't mean, by the way, that I'm saying that in every case you're going to be dealing with a situation where you're going to be selling the family home. That's not what I'm saying. What I'm saying is you're going to be looking at all of
and it seems to me, from anecdotally, I hear that, sometimes people come to an agreement, they'd live under the one roof.
Correct. Quite common, yeah. Not uncommon. In fact, I remember one of the cases that I had way back when, at the very early stages, this was literally, they put a wall down through the house, and I don't mean almost literally a wall down through the house. And he lived on one side of the wall and she lived on the other side of the wall. Yeah. And that was the practicalities of it, and that's what they were literally looking over the wall at each other, but they did that and lived like that for quite a number of years. It was like the other one that was very common at the very outset of my family law practice, was the whole idea that, you couldn't have shared parenting. You couldn't have a situation where the child could go from one household to another household. And I remember I was involved in a couple of the very early cases where there was shared parenting, and it worked. A lot of what will work will depend on whether it's made to work or not.
It's interesting. There was a perception that, particularly years ago, that the man would come out worst out of any of these situations, really, whether it was a court or even a mediation.
Very much so.
Is that still the
It has changed somewhat.
Yeah.
With our people like our friend Bob Geldof. I remember he was a huge exponent of that, and a huge advertisement for it, because he actually took on minding the children, if you know what I mean. But there was, and again, I like a lot of it's, broad generalizations. In my experience, once the parties, there has been a huge shift. When I started family law first, however many years ago, I'm not going to say how many years ago, but even the pre-divorce period, if you know what I mean.
Yes.
At that stage, you were in a situation where you were being kind of told, there was never any, you were the one I got was you'd be pushing a boulder up a hill trying to argue that the father would be the primary carer, and there was no look to the circumstances to see whether or not that should be the case or not. It was a
given.
It was a given.
Yeah.
All of that has certainly changed in the recent past with the whole. And if you think about it, not to be unfair to that period of time, it was very much the norm. It would be very much the exception.
Family law, of course, has evolved, John.
Hugely.
Yeah.
Hugely. And still evolving. And I remember it was maybe 15 years ago, I was at a conference involving Canadian judges, and Texas judges, I think, and the Irish judges, and they were all sitting around talking about what needed to be done in the family law system in Ireland compared to these other jurisdictions, because these other jurisdictions were way ahead in terms of what they were talking about. Now, we've been talking about it, not unsurprisingly, for the last 15 or 20 years since the various reports were published about introducing mediation as a kind of you almost can go into a court scenario and the judge is a trained mediator. There's a mediation expert available to you. So the whole focus is on trying to put the resources and make the resources available to the family to support them. People who have never had no knowledge of what's involved in the law or the legal system, and the whole separate courtrooms, separate court system, trained judges, all of that is on the cards, as in the government of whatever the plan of government, whatever the term is that you have. It's all there, and the Act has been published and we're waiting for it. And then the question you're going to have is, will the resources follow? And if the resources don't follow, it ain't going to work. But I mean, this was however many years, it was at least 10 years ago. I remember sitting listening, wow, that'd be an incredibly, like, I mean, people are still standing around in courts, you know, in a big hall, like lost, waiting to get on their case, and then come down one week, and then they come down the following week, and then a month later they come back again. We're still dealing with, anyway, I better get off the horse.
Yeah, but it's very interesting to hear that. What else by way of resolution, John, should we be?
Well, the other one that you're looking at is should you have an agreement on regularising your position. So what I mean by that is there are a lot of people who are sole traders who possibly should consider, having a limited company. And the very simple reason you have a limited company is that there's limited liability there, and you're not personally exposed. It has the additional obligation that you have to do reports every year, but that to a certain extent is also beneficial because it means you got to keep your books in order.
Yes.
And you got to, so there is benefits in that. The other one, of course, is that there's a lot of people out there still that do set up companies and they're friends and everything is fine, etc., etc., etc. Something goes wrong, and the very first thing that you ask when they come into you on a dispute is there an agreement? Is there a shareholders agreement there? Because at the end of the day, a shareholders agreement is the way of sitting down with somebody and saying, okay, what do we want to happen? For example, if one of us wants to get out, what do you want to happen if one of us passes and dies? Where does my interest in this company go? Because who might or might not want somebody's family getting involved in a business that they really had no knowledge of? So there's where your shareholders agreement comes in. The other one then, of course, is people in partnership. If people are in a partnership, they should have partnership agreements. And then, there's a kind of a raft of agreements that you should always be looking at. So, and the big one, the big absolute one, that funny, bit like we were talking about wills, and you and I have often asked the question, why don't people make wills? And we've kind of tossed it out there a few times. But one of the things that certainly you'd have to ask as well is, if people are living together, why do they not have cohabitation agreements where they're living together for a long period of time and they're in a committed relationship? Now, if you're in a committed relationship, you're covered by the Cohabitation Act. But the question is, do you want to be covered by the Cohabitation Act? Are you happy with the terms of the Act? Would you not be better doing your own agreement? The answer is yes, you would. Because, like everything else, not everything is a little bit like our electrical goods. They're not made to last anymore. But the reality of it is that if you have a breakup, the time to talk about it is not when you're having it, but it's before you have it. And because then you're in a position to say, well, okay, people shy away from it, they shy away from it.
It's like the prenups as well.
Yeah,
it seems to be.
exactly.
Yeah.
And the prenups are the same.
Yeah.
Having said that, I've got a couple of inquiries since the new year, why, I'm not sure, but again, the same thing. But if you look at a cohabitation agreement, prenup, yes, in anticipation, it's kind of hard when you're going down on one bended knee to be holding up, instead of the ring,
The ring
to
of
be holding
one.
up the share, the prenup agreement.
In the
So
other
maybe
hand,
wait until you're, do it maybe before you go down on the knee.
Yeah.
And then maybe you go down the... But yeah, cohabitation agreements. And then the other thing that is very, very important, and we're back to will scenario here, where you have what I call a blended family, a will is critical. Because, what do you do if you have stepchildren? What do you do if you have your own children? How do you treat them? And how do you make sure that everything's okay? What do you want to do vis-a-vis your partner? And, whether it's blended or married blended or unmarried blended, it's the same thing. You should have a will and you should be dealing with it. And you should be sitting down. And you and I talked about this the last time. And I said to you, making a will, doing a shareholders agreement, doing a prenup agreement, any of these things, it's a process. It's not in, out, there you go, thank you very much, go down to Easton's and pull it off the shelf, fill in the blanks and away you go. It's a thought process as much as an act of executing a document. The document takes, like if you think about it, one of the other things we could talk about is conveyancing and the whole land scenario. Yeah. But the reality of it is that if you're buying a house, it takes time. Why? Because it's a process. Why is it a process? Because you have to go and check everything out to make sure everything's okay, and you also have to understand what you're doing. A will is exactly the same. Should take around the same time to do it. Now, move on to the other type of agreement that you should have, and the other one that causes trouble all the time. Two of them that comes to mind. One is if you're in a situation where you're buying a house with somebody else. People just go in, sign a deed, and they think that's fine. But it's not fine, because the amount of times, a couple of years later, one or other then comes back into you and goes, well, we're actually separating now, and there's no agreement. What happens about it? And I paid this, and she paid that, and no, I didn't, and she's not agreeable to sell it, and whatever.
Make the agreement.
Make the agreement while you're able to have a discussion without a row. I don't know, maybe that depends.
No, but I mean, it's simple advice, but it's at the end of the day, you see the result of not doing that.
Exactly, and it is seeing the result of not doing it.
Yeah.
And you kind of go, genie Mac, the amount of people that come into you after the fact who said, I know you told me to do it, but it was going to be an extra €750 or whatever it was, and I didn't really want. And I said, well, look, it's like the person who came into me. I remember, and again, it comes to my mind as I'm talking about it. One of the things that people are always trying to do is save money, which is fair enough. But there's saving money and there's wasting money. Saving it, you can waste it by saving it.
Yes.
Because at the end of the day, it reminds me of the client who came into me it was on a Tuesday morning, and we'd closed the sale on the Friday. And before we closed the sale, I said, have you surveyed the house? Have you done it? Have you got an engineer? Jesus, no, I don't need an engineer. Show me, what is your man? I have a friend who's a builder. And I said, look, you're investing a huge amount of money in this house. Why would you not get a professional to go in and have a look at it? No, I don't need it. Anyway, Tuesday morning, they come in anyway. There's a big crack in the chimney.
Good God.
Huge crack in the chimney, which they only discovered when they lit the fire.
Wow.
Because suddenly smoke going all over the room. They go in, they check, and the flue is split all the way up. Now, I bit my tongue. I told
you so.
I bit my tongue because I didn't need to. I didn't need to do anything. They were always saying, Jesus, John, you told me. And I said, well, fair enough, but now what can we do? And of course, the very first thing is, can I sue? Can I sue the fellow who sold me the house? He never told me about the flue. I said, I'm sorry, you can't. It's caveat emptor. It's a principle of law. I told you about it at the time.
Caveat Emptor. That means what? Beware.
Buyer beware. Yeah. Caveat emptor. Lovely Latin phrase. Caveat emptor.
Fascinating as usual, John. Thanks very much indeed for that.
I think I'm finished.
Are we done? Are we done our resolutions? Wow. All right, thanks, John. We'll take a break. Back with more.
Tip FM's Tip Today.
With Slattery's Garage Puckon. Now is the time to pick up your next van. From the award-winning Peugeot Partner van to the Expert and the load-lugging Boxer van. We have big vans, high-roof vans, long wheelbase vans. You'll find them all at Slattery's Garage Puckon. See slatterysgarage.ie.